Sehr geehrter Herr Breitenmoser, meine sehr verehrten Damen
Mr.
und
Breitenmoser, ladies and gentlemen, let me first thank you for your attention. I would like to give my talk on the legislation of the ECG, starting with the constitutional crisis in Hungary and Poland. Article 7 of the Treaty on European Union on sanction proceedings is the article to resort to when dealing with the systemic deficits of the rule of law. But this has proven to be a blunt sword because in order to ascertain that a member state committed a serious and persistent breach of the values set out in this article, we need a unanimous vote in the European Council. These proceedings have been initiated under Article 7 TEU, but a determination is yet to be made. The Commission's proposal whereby member states that fail to comply with rule of law principles can be penalized with monetary penalties. This is called the rule of law mechanism. The European Commission, the proposal for regulation of the European Parliament and of the Council on the protection of the Union budget in the event of general shortcomings in relation to the rule of law in the member states. This has been adopted, but this has been watered down. It is a mechanism that is mutated into a kind of anti-corruption mechanism. Poland and Hungary intend to file an action for annulment against the regulation of the ECJ in the event of such a measure, but according to the decision of the European Council, the decision to activate the mechanism must be taken, only then can it be included in the guidelines. Against this background, the ECJ has already become active in the past and has used a series of proceedings to grant itself control access according to EU law to check judicial independence at the member state level. The focus is on Article 2 TEU and the promise of the Union of Values to uphold the rule of law. In 2012, in Arman versus Bogdandi, it has been rightly noted that many thought this was almost legal science fiction to activate Article 2 TEU in judicial proceedings. But as in Jules Verne, utopia has quickly become reality. But let's take a closer look. I want to explain the ECJ legislation in 3 phases. The first phase is a prelude, so to speak. I want to talk about the infringement procedure. This was based on a decision taken in Hungary to reduce the retirement ages of judges, prosecutors, and notaries. It declares that by adopting national legislation for judges, public prosecutors, and notaries, this will result in a difference in treatment on grounds of age. In fact, no dogmatic ground or no new dogmatic ground was broken here. Anti-discrimination jurisprudence has always been progressive and not very competence sensitive. But this ruling didn't have a lot of impact, a major impact, because in the wake of the infringement proceedings, the Hungarian government passed a discrimination-neutral law that offered judges who had retired early, they were offered a lucrative compensation as an alternative to their removal. And most of those affected opted for this compensation. Then I'd like to talk about another case, the suspension of European arrest warrants due to unacceptable detention conditions in Hungary and Romania. The ECJ reversed or made the principle of mutual trust more relative. And the execution of a European arrest warrant can be suspended for 2 reasons or 2 conditions. First, objective, reliable, accurate, and duly updated information on the conditions of the detention in the member state must demonstrate the existence of systemic or general deficiencies affecting specific categories of persons or specific detention facilities. Secondly, there must be serious grounds supported by the facts for believing that the person concerned will also be exposed to the risk of inhumane or degrading treatment. With this decision, the ECJ reacted to a decision of the Federal Constitutional Court on the European arrest warrant dating December 15, 2015. Until this decision, it had considered the principle of mutual trust in this area to be practically irrefutable. But important impetus was given by several decisions of the ECTHR on inhumane conditions of detention. But neither the Federal Constitutional Court nor the ECJ could or wanted to ignore these rulings permanently. Now, this brings to the second major phase, and this was almost a drumbeat. This refers to the ruling of the 27th of February 2018, taken by the ACJP, the Portuguese Association of Judges. There's hardly a decision of the ECJ that has been described as groundbreaking, far-reaching, and spectacular. And Leonards even compares it with Van Gent on Loos and Costa ENL. But the subject at hand is actually quite easy to structure. The members of the Portuguese Court of Audits, or the members' salary was actually reduced. But the actual fact was straightforward. In response to the sovereign debt crisis and in connection with the Union Financial Assistance Program, the salaries of the members of the Portuguese Court of Finance were also reduced by a certain percentage. But it was spectacular because this way was quite dogmatic. The ECJ links Article 19, subparagraph 2 TU with Article 2 TU and Article 47.2 of the Charter on European Fundamental Rights, and takes from these provisions the obligation of the member states to guarantee legal recourse to national courts and effective legal protection. The prerequisite for effective legal protection, according to Article 47.2 GRC, is an independent and impartial court. But the concept of independence presupposes, amongst other things, that the body in question exercises its judicial functions in complete autonomy without being hierarchically linked to or subordinate to anybody and without receiving orders or instructions from anybody, and that is thus protected from outside intervention or pressure that could jeopardize the independence of the judges in this body. But what was that spectacular? Well, I refer to the articles that say that all member states need to make sure that there is legal recourse so that there is legal certainty in the European Union. This is a general supervisory norm for the European Union. But the positive values of this article has become a structure savings clause, basically. So Article 51(2) needs to be discussed as well. And this leads to a situation where all courts of a member state are subject to these norms and standards. So it is a systematic monitoring of the rule of law, even though it is supposed to be about breaches. And then we have the Article 49 of the TFEU, checking the legitimacy of a trial. But this decision leads to a material checking of the system. And this is a danger for the equality in the federal structure. And this legislation has been made more concrete in many rulings and decisions. We have the preliminary ruling procedure. I would like to point to the procedure LM. It defined the potential reasons why a European arrest warrant could be suspended. It also defines the reform of the judiciary in Poland and the infringements in Hungary. So the basic principle of mutual trust says that the criminal courts need to abide by certain requirements, of course. For instance, there need to be independent and impartial. If a person affected says that or proves that there are systemic deficits in a given member state's legislation that might interfere with judges, the judiciary, or infringes their independence, then the authority can suspend a warrant according to a two-tiered process. There were other cases, like the one where Spanish judges' salaries are reduced, or the composition of Polish courts, and the infringement of an independent disciplinary proceeding in the disciplinary chamber, or the changes in the procedure where members of a certain judicial committee were nominated, also in Poland, and the decision's legal protection. The ECJ defined a principle and these things can be read about in the different articles. It is incompatible for the system if judges still get a salary but the authority needs to check It was made clear with the proceedings in Poland that they did not per se question the independence of the courts, but the affected courts needed to check the independence. The rules to nominate and appoint judges need to make clear that the judges to be appointed have to be independent and impartial, and the respective court or courts need to see into that. There were two commissions, two proceedings initiated by the Commission on infringement proceedings. The ECJ saw an infringement with judges' independence, but there was a specific focus on the modality of the prolonging of the term of office. This is in the president's discretion, the president of the different member states, but there is a prerequisite for expanding the term of office and its modalities. They need to make sure that they do not infringe on the judges' impartiality and independence. They must not be subject to external interference. There are certain criteria that one needs to observe when deciding to expand a judge's term of office. But the system in place needs to make sure that judges are not subject to external interference. In Poland, judges, there is a rule for the judges' term of office. It's linked to retirement age. So this infringement proceeding is much more effective for monitoring the rule of law in a given state. The burden of control lies with the court. The ECJ's requirement for a systemic analysis in the different member states can overtax certain member states. And there is a danger of repressions in member states coming from the supervisory body or authority. Infringement procedures can also entail the threat to impose fines. The ECJ has its own access to control, and the ECJ has expanded this control, and that was rather dogmatic. The capabilities have been expanded. Article 47 of the infringement proceeding is to no avail, and there's also a lack of other effective control mechanisms, and they need to be alleviated. The costs of this, I call it judicialization, can be quite high in the medium or long term. Article 19, 1, 2, together with Article 2 of TFEU, the ECJ has full access to all non-harmonized fields. That's what it decided on. When checking the democratic rules in a given member state, this modality can lead to basic conflicts at a quite early point in time, I might assume. There are two decisions that might tell us what Germany could expect. There might be a ruling by the ECJ in line with Article 6(1) from the framework decision of European arrest warrants. And it's not about the member states' attorney generals or a single decision coming from the minister of the judiciary. There is a ruling from LG Lübeck and Zwickau that are also interesting. The president of the Constitutional Court in Wiesbaden also asked whether whether court is actually independent according to Article 267. Doubts were voiced concerning its own independence vis-à-vis the executive and the legislative. This president said that, well, firstly, the judges are supported by the Ministry of the Judiciary and nominated by it. They have to observe the same rules and regulations as official clerks in Germany. And the Ministry of the Judiciary stipulates what kind of databases or programs they have to work with. And judges are appointed or can be appointed for a given period of time. And the internal organization of courts is also stipulated by the Ministry of the Judiciary. I said it before, this includes databases, programs, and also the Ministry of the Judiciary can also decide on judges' trips and journeys. And this is quite shady. So all these reasons that I just explained are not sufficient to say whether or not it is independent. So the control mechanism I referred to before could have led to a different interpretation. So it remains to be seen what the ECJ says about what was decided in Landfurt. But they had a similar argumentation as the court in Wiesbaden. It is really difficult to come to a comprehensive conclusion.